It's about similar philosophy where challenge is made to Rule 32. Application for amendment is
order which we had passed yesterday, same. Same.
That is covered by what judgment in order. Matter pertaining to order deemed conversion under section 95(9), and matter is covered by what judgment at the next section. F1.
Page number 61, Lord. Page number 63, date of the application is 1/4/2022 instead of 7/1. And in page number 64, in E, instead of quarry, a stone crushing.
Date of application?
1/4/2022.
1/4/2022.
B and C, in B and C. And in E, for the purpose of quarry only, instead of stone crushing.
Page 63.
Number 3.
But petitioners will not the traditional practice of stone cutting workers. But from time immemorial, my lord, they were working the stone cutting work in survey number 78 of Misgan. In meantime, middle of the lord, recently, my lord, some people have tried to torture and assault you to evict from the place. Therefore, my lord, we placed a representation in the villages. We formed the society and we had a representation before the respondent authority, and that has not been considered. It's only the livelihood for them, not for survival.
What is this work?
But you see,
what is this work which they carry?
But the stone cutting work by practice, from time immemorial, they're cutting the stones for the building constructions, and they are traditional stone workers. That is their work. It is a community. Only they will do the stone cutting work for the construction of buildings and borders. And now some of them, the people are coming there and obstructing them not to do the work. Therefore, my lord, we have placed a representation to the Tahsildar and the fourth respondent and other respondents. Not to give the protection and grant it's a government land.
Who is coming and stopping?
Well, fourth respondent. Fourth respondent. The Deputy Director Department of Mines and Jewels.
The director is stopping you from working.
Yes, yes, sir.
Is there any restraint order?
No, there is no restraint order. Simply they will come to this spot and they will asked me to go out of the place.
Yes, what you say? They are traditional workers. They say that they have been performing this work of stone
Without
cutting.
license, they cannot. Without license or lease, they,
The traditional workers.
for traditional workers also there is a provision lot under 3 years. They will be granted quarry leases. Without which they cannot do. It amounts to illegal quarry.
We are not doing quarry matter. From time immemorial, this is a tradition, this is the work we are doing it. We are doing some boulders with the
You
hammers.
consider their representation.
Consider not.
Right? The license is required for quarrying.
Yes.
They specific cases that they are not doing any quarrying. They are only stone cutting for the construction of buildings.
No, no. Their case is not, they are quarrying in the government land wherein the
No.
authorities are. That is what
No, it is my specific case. My lord, I am doing stone cutting work. My lord, you have photos I have produced, you let me kindly.
in government land.
That is time immemorial, it's a photos my lord I have produced. That is the work, my lord, that is only sources for them for livelihood.
You decide the representation. Who will consider your representation? State government?
Yes, respondent 4 and 6. Respondent number 4 and 6.
No respondent. State government will have to consider.
Yes, state government. Respondent number 1 is.
How can respondent number 4 may consider?
Because the representation is made to the deputy commissioner.
Then you
and
make a representation to the
I have
state.
given to all the representation to everyone, my lord, wherever,
let them
even to
file
the
a
state also.
representation to the
Make a
government.
fresh representation
Yes.
to the state government.
Yes.
Because it will be a policy decision
Yes.
that has to be taken by the state government.
Yes, my lord.
This public interest litigation has been filed seeking following relief. London Council for the petitioner submits that the people belonging to Hovi, in brackets, scheduled caste community from Mesa Ganahali village, Karahali Gram Panchayat, Kundana Hobli, Bangalore Rural District are involved in traditional stone cutting work from time immemorial. They have been doing the work of stone cutting in survey number 75 to an extent of 28 acres, which belongs to the state government. It is submitted that the state government shall protect the community Bhovi who are involved in traditional stone cutting work, which is meant for building construction. London AG, on the other hand, submits that the license is required.
Yes,
License is required.
quarry lease or license. Quarry lease.
Quarry lease or license is required for doing such work on a government land. Unless the quarry lease or license is granted, nobody can be allowed to involve himself in stone cutting work. Be that as it may, since it relates to para, since it relates to, be that as it may be, relates to the people belonging to a particular community, that is Bhovi community, we feel it appropriate that the state government may consider their grievance and take appropriate decision in accordance with law. The writ petition as such is disposed of at this stage with liberty to petitioner to raise their grievance by way of a representation before the respondent number 1 within a period of 10 days from today. In case any such representation is made, it is directed that the first respondent, that is Secretary, Department of Mines and Geology, shall consider and decide this representation of the petitioner in accordance with law. Expeditiously, the decisions so taken shall be communicated to the petitioner.
Until then, they are not supposed to come to this part. Number 4.
Without even show cause notice and you are without hearing the petitioner, my lord, as required under law, a demand notice for penalty was raised as per the impugned order for the alleged unauthorized quarry operation. My lord, under Rule 44, Proviso 4, my lord, it is clear that, my lord, there should be a show cause notice and I should have been, petition should have been heard, then only the order could have been passed.
Where is the impugned order?
Page number 16, my lord. The relevant portion, my lord, at page number 19.
Yes, what do you say?
And it's covered by the lordship judgment, my lord.
Not, he was present during DGPS survey. However, there is no show cause notice after that was issued. Instead of that, not deputy
We have
director.
passed some orders. We have passed some orders that it may be treated as a show cause notice.
Yes.
Annexed the same in page number
Annexes, yep, my lord.
G, as per Annex G.
Annexes G, my lord. 93.
Page
93.
93.
93, my lord. Lord, relevant paragraph is paragraph 6 and 8, my lord, page number 96.
Para 8, 97.
No, we have also passed this bench.
Yes, your lordship also passed.
So far as this DGPS survey is concerned, in this particular case, his contention was that he was not present, whereas in the order, he was very much present. However, not this order may.
Survey report should have been served on us.
We have passed the order that this notice may be treated as a show cause notice and he may file a reply to this show cause notice within this period and thereafter decision may be taken till any decision is stated, no coercive action shall.
Yes.
Where is that order? Heard? Notice on behalf of respondent shall be accepted by learned AG since only a trivial question is involved in the petition as such. With the consent of parties concerned, we dispose of this petition at this stage, admission stage, without calling for a statement of objection. A petition has been filed challenging the impugned demand notice dated 11/4/2022 issued by second respondent, copy of which is annexed as annexure number 8 to the writ petition. Learned counsel for the petitioner submits that no opportunity whatsoever by way of show cause or otherwise was provided to the petitioner before issuance of the impugned demand notice, and as such, the impugned demand notice is arbitrary and bad in law. It is submitted that in case an opportunity was provided to the petitioner would have been in a position to demonstrate that the impugned demand notice is bad and is wrong. Full stop. Yeah. The AG appearing for the respondent, on the other hand, submits that although no show cause notice was issued to petitioner before issuance of the impugned demand notice, however, the impugned demand notice has been issued on the basis of survey.
Survey, DGPS survey.
Eh?
DGPS survey.
Drone survey.
Drone survey.
DGPS survey carried out by the respondent
When he was present.
in the presence of the petitioner. Since the demand notice involved civil consequences as such, we are of the considered view that before issuance of the impugned demand notice, an opportunity should have been provided to the petitioner. In view of above, we pass the following order. The impugned demand notice shall be treated as a show cause notice to the petitioner. So, number 2, the petitioner shall submit his reply within 2 weeks from today. Okay. The competent authority, that is respondent number 2,
Yes, yes,
Deputy Director,
yes.
the respondent number 2, thereafter shall pass appropriate orders considering the reply of the petitioner in accordance with law within a period of 3 weeks.
3 months. Within a period of 3 months.
3 weeks. Within a period of 3 weeks.
Not now.
4. Till the decisions so taken shall be communicated. Number 4, decisions so taken by the Deputy Director. Respondent number 2 shall be communicated to the petitioner. 5. Till the decision is taken as provided earlier by the second respondent, no coercive action shall be taken against the petitioner. With these observations, the petition disposed of.
Right. But you have suspended query operation. You have suspended my query operation.
Let them take it. This is
Number 5, Sampak A.
This is pertaining to the Arkavati layout, please. Lordship was pleased to connect to
Writ appeal number
Writ appeal number 1319 of 2021, please.
1318.
1319, my lord.
1319 of
2021.
21.
Please, my lord.
This intra-court appeal has been filed challenging the judgment in order date 27th of September 2021. Some matters were also dismissed.
No, my lord, that is another matter, not Arkavati layout matter.
Eh?
That is different, my lord. This is Justice Arvind Kumar's order. The lords have issued notice in these matters.
279, my lord, the order.
That dismissal, my lord, Justice Krishna Kumar's order relating to another layout, not this
Shivaram
relating to
Karan
Arkavati layout.
Somehow I have got this impression that in this also, some only in one matter, the indulgence was granted. Otherwise, all the appeals were dismissed.
No, my lord, it is also the same issue, my lord. It
It was connected to our petitions only, another matter.
Eh?
He himself has filed that appeal, my lords. I know that in my lords has issued notice.
Please, my lord.
It is same.
Please, my lord, the same. We ourselves has filed, my lord, another matter. It was also connected.
It's connected. Other such and such. Then it AJ shall accept notice
First is
for
one number 1.
respondent number 1. Issue notice to respond number 2 and 3. PF within 1 week. Counsel for the appellant informs that against the impugned judgment and under similar facts and circumstances, the writ appeal number 1319/2021 has been filed, which is pending consideration. The full stop. List after 3 weeks, along with the writ appeal number 1319/21. The petitioner number 3 has died.
Please, my lord, he has died during the pendency.
You have not impleaded him, no?
It was not impleaded, my lord. He has
All
died.
right. No problem.
He has also died bachelor. I don't have any issues. I filed a memo regarding that.
All right, all right.
Please.
Number 6.
The challenge that was made by the respondents was acquisition proceedings in 1985-86 were challenged by the father of the respondents. They lost in the writ petition, they lost in the writ appeal, the decision became final. Possession was handed over to the housing society, which is the appellate before your lordships. Layout has been formed, sites have been distributed. Lord, they come back for a second helping in 2018 on the strength of a gift deed executed inter se between the family members. Lord, one of the two principal grounds of defense that was taken by me before the learned single judge was first that these proceedings are barred by res judicata because the challenge made to the acquisition has been upheld by the division bench of this court. Two, that possession has been delivered under section 16(2), and after the lands vested in the government, possession has been delivered to the society also. Lord, compensation amount has been deposited before the land acquisition officer in LAC proceeding. Lord, the learned single judge, not relying on Indore, only goes to the extent of saying that possession that was given to you was only paper possession and that there is no mahajar that is produced. But he doesn't take into account the fact that compensation has been paid. Your lordship knows those both the conditions required to be satisfied. Non-payment of compensation and this thing, Lord. Therefore, I am before your lordships now. Your lordships looks at annexure J for a minute, Lord. That is the learned single judge's order in the previous round of litigation. Annexure G, page 121. 121.
Yes.
This is Patel Bhairappa. That is the petitioner's respondent's father. Same preliminary and final notification. If your lordship looks at page 121. Quash annexure A dated 22/85 and annexure D dated 27/2/1986. This writ petition is dismissed, and the writ appeal order your lordship will get at page 134. Now please look at the writ relief that is sought for at page 32. Or I'll take your lordship to the writ petition itself, page 65. Second relief your lordship may see at 65. Same preliminary and final notification. Your Lordship looks at Annexure J at page 154.
All right, can you serve them outside court? Respondent,
Pardon, my Lord.
can you serve them?
Um,
Take notice to them?
would your Lordship permit me to take out notice to the counsel who was representing them before the learned single judge?
Yeah, very much available in Bangalore. Why don't you serve them?
Very well. Very well.
Take me
Your Lordship saying Dasti, my Lord? Very well.
Heard? You should notice to respondent the notice for respondent 1, 2, and 3 shall be accepted by learned AGA. Issue notice to respondent number 4 and 5. Returnable at an early date. PF within 3 days. In addition to the regular mode, the appellant shall take dusty notice to respondent 4 and 5.
Informing the date of hearing as ...
The office shall issue dusty notice to counsel for the appellant in this regard. List, give a date.
Lord, I've sought for an interim order, my Lord. Your Lordship
Will
may.
consider, let them come.
Lord, what will happen is, if they were to develop the land on the strength of the learned single
Give a
judge,
short date, 1 week.
24th June.
24th June.
6 days delay.
The delay is
Lord, that.
controlled in view of the Supreme Court order as per of the Supreme Court.
now there are two office objections. One is that the photographs.
In the meantime, the counsel for appellant shall make good the office objection.
No, your Lordship sees the office objection is that the respondents who were the petitioners before the learned single judge had produced some photographs. They were color photographs. Lord, I don't have access to those color photographs, so I have produced black and white. Your Lordship may just overrule it for the present, my Lord, because after they come, then your Lordships may direct the respondents to comply with that.
Other office objection.
One more is that there is a layout plan. Say that it was produced by the petitioners before this learned single judge. I don't have access to that. So both those may be kept open. Your Lordship may say till the appearance of the respondents or in abeyance.
Objections raised by the office are kept in abeyance till the appearance of respondent.
Great.
It's I appear for respond number 6. It's I appear for respond number 7.
I am appearing for the response number 6, my lord.
Order, my lord. With regard to the encroachments has to be cleared by the respondent number 6. So far, some of the structures they have removed. Only this respondent number 7 structure has not clear. To that extent, the respondent number 6 has given a statement before when the show cause notice was given. This building was constructed before 2010. But the land was purchased in the year 2010 itself. This big structure was completed in the year 2015. I have got some documents to show, and also Google map where it shows that 2007, 8, 9, 10, 11, no structures. Order of 20th 12/2021, my Lord has clarified it.
12?
20/12/2021. In the middle, 2012/2021. It was clarified that whether the third respondent has to clear the illegal structure or the sixth respondent. This court has clarified it. Very particularly, the 8th line, my lord, it was on that basis. The court had clarified that it may be respondent number 3 or the respondent number 6 who may be a respondent for removal of the encroachment, and the state government shall direct the concerning competent authority in this regard and shall see that the encroachments as found in the said survey report are removed.
Now, in the report, certain encroachment were found and they were required to be removed. There was some confusion regarding who has to remove it, respondent number 3 or 6.
That is clarified now. The sixth respondent has to
clarified that state government shall direct the concerning authority to remove it.
Yes, we have directed my lords to the sixth respondent to do it, and accordingly we have filed compliance before this honorable court.
Now, what has happened?
The sixth respondent has to say he has issued show cause notice.
Yes, my lords. My lords, I am for the sixth respondent. We have removed all the encroachments, and this is regarding the seventh respondent's encroachment is concerned. It's an old building, and it is not. It's an old building. No buffer zone was encroached, but it's prior to the coming into force of the act that building was in
with respect to the encroachment by the seventh respondent.
Yes, sir.
You are required to remove it.
My lord, it is land belongs to him in the buffer zone. No lake area was encroached, my lord. And it's an old.
The report whether the construction done by the respondent number 7 has been found to be encroachment or not.
No encroachment. It is in the buffer zone, my lord. It is not an encroachment, but it is in the buffer zone. Land belonging to the seventh respondent, but it is in the buffer zone, my lord. No encroachment of lake. It is a buffer zone.
Perpetual, yeah. What he is saying, sir?
He said that the land, he does, respondent number 7 has not acquired any encroachment on the that it is he has constructed within his own land.
You are appearing for a seventh respondent.
I am for the sixth respondent.
Yes.
I am for the
Senior counsel is appearing.
I appear for the seventh respondent.
Yes.
That's my learned friend. My learned friend is not informing the court the correct position. The report says I have not approached. That report is before the court. He has not objected to that report. He can't be saying something contrary to the report. Well, it's the first and foremost objection I have is kindly see the prayer.
Rest other encroachments have been removed.
Yes, madam.
Plus, insofar as I am concerned, there is no encroachment.
I will clarify here, my lord. There is no encroachment of the tank bed area, my lord. But construction is there in the buffer zone, and which is constructed after the coming into force of the act, my lord, that has been removed. The construction, insofar as the seventh respondent is concerned, it is in the buffer zone. There's not an encroachment, my lord.
All right, yes.
Report, my lord, report filed by my lord, AGA on 4/3/2022, my lord, may kindly see, my lord, it is on the file.
Yes.
4/3/2022, the report has been filed, my lord.
Now, what is your stand?
I stand is that is
The
the
report says I have not encroached, so question of
survey has taken place. The survey report is there.
Whether
It comes within the buffer zone, madam. It comes 100%. It is under the buffer zone. The survey report is also filed. It is in the color they have mentioned.
in this report, it is said that the construction done by respondent number 7 is not encroachment.
No.
No, there is no encroachment.
No encroachment.
You have not find any objection to that.
No, I have got the objection, madam. I have got the objection. I have already stated. It is the survey report is very clear. There are 9 encroachments. Already 7 encroachments are clear. They themselves has taken out, and there are 2 members who have came before this honorable court as a impeding applicant. I have no objection for that.
We will have decided finally. We will decide it finally. We'll fix the date for final hearing.
Any day, madam. I will file my counter, detailed counter. How the 6th respondent is hand in glove with the 7th respondent, stating that this building is comes with before 2010. The land was purchased in the year 2010 only. This big structure has completed in the 2015.
Impleadment on who as respondent? That is not possible. You cannot be impleaded as petitioner. Sorry. Where is impleadment application that we will reject? We will give you liberty to file petition if you want. Are you?
5 of 22.
Third on IA 5 of 22 is an application for impleadment by IA 1 5
1 of 20.
Year 5,
Year 5.
5.
One complaints of office operation, but even IA 1 is also IA 1 TA Karumbai.
by 1 KA Ravi Chengappa. The applicant wants to be impleaded as petition number 2 in the writ petition. Sir? We are of the conceded view that in case petitioner is aggrieved, he may file appropriate case before the appropriate forum. However, he cannot be impleaded as petitioner in the present case. The application is accordingly rejected. It appears, next, it appears that pleadings have been exchanged. This is the matter for hearing.
EL rules to be complied with.
The petitioner, the party in person, shall comply the office objection regarding PIR rules.
It is everything is ready, my lord. 2 IAs are changed because they are the adjacent owners. Now he has already cleared the road. If their applications are allowed, once again I have to include them as it. Therefore I have kept it pending. If that IAs, one Karambaya advocate has filed that application.
Which IA?
IA2.
IA2 with respect to stay or stay.
I have no objection if they come on the record, because they are the adjacent landowners.
They moved application for impleadment. Where is
Their encroachment is already removed, my lords. Their construction is already removed.
Like on IA1 of 22, heard on application for impleadment, moved by one BJ Roshan, former Purushottam K and Lohit K. The applicants wants to be impleaded as respondent in the present proceedings. The party in person, para party in person, submits that he has no objection for their impleadment. The application is allowed. The respondent, the applicants, such and such shall be impleaded as respondent number 8, 9 and 10. The necessary impleadment shall be carried out within 1 week.
2 weeks time. I am everything is ready, madam. Only impleading and
List, don't write for hearing, list thereafter.
Number 8, Kulkarni, 14%.
Lord, I have the petitioner in this case. My lords,
Office objections.
all have been complied with, my lord. I have written a form according to public interest in litigation rules also. I submitted that also, my lord.
Still, office has reported 6 office objections.
All have been complied with, my lordship. I have submitted. Perhaps they have not, the register has not noticed it. I complied. I have written the pro forma here also. I have written High Court rules also.
We'll call for the report again.
My lord.
As per office report, 6 office objections are reported. Parallel, the petitioner who is party in person, states that he has already complied. The office objections. Office may file a fresh report after verification. Give it.
My lord, may I request that if anything is there, it can be dispensed with, because the Supreme Court judgment that in PIL the technicalities coming in the way of public interest shall be ignored as per SOMA isolate CH-1 tolerate private interest.
High Court rules are here for PIL. PIL rules have been framed here, which are required to be complied.
My lord, my kind lordship, I have already done. Kindly
Well,
post.
we have called for the report from the office. Let the report be filed.
Yes, my lordship.
19-7. Number 9. Ranganath Edgewise.
I appear, my lord. I appear for the complainants, my lord. The matter relating to the directions issued in the respect of daily wage employees, my lord, who are the complainants. 2 directions were issued, my lord, page number 14. One is regarding the private contractors not paying the Provident Fund Labor Act not being followed. Second condition was about the daily wage employees, whether come under the Daily Wage Welfare Protection Act of 2012. Kindly see page number 14, my lord, para 3. Per contra, the learned High Court government would submit that the range forest officer is not authorized to issue any endorsement to the representation submitted by the petitioner. Be that as it may, the issue as to whether they are entitled for any relief or should not be permitted to hang fire, as it has been that the petitioners are in all the late 40s. The claim of that they are being exploited by the labor contractors cannot be without any element of truth, as it is their specific allegation that the labor contractor has not complied with mandate of Labor Act or the Employees Provident Fund Act and Miscellaneous Provisions Act of 1952 and the Payment of Gratuity Act. In the light of the above factual submission, in the endorsement now the one direction was to comply with the hold an inquiry shall initiate action against a labor contractor by blacklisting them. This was one part. Second portion was to consider under Labor Act. But now they have issued an endorsement, say that 2012 Act they have complied. But so far as the Labor Act not being complied as per para 4, they had not conducted any inquiry and they had not seen whether the labor contractors have complied with the provisions of the Act, for which the endorsement does not speak anything.
Lords, they filed an affidavit on 15/3/2022, my lords. It's an office objection regarding translation, my lords, because at that time the translation was not required. We had filed, but now
What you have complied?
Lords, the direction, my lords, is at paragraph number 5 of the judgment, my lords. Lordship says, the respondent number 2 shall also consider the claim of the petitioner for the benefit under 2012 Act. It is common knowledge that the Forest Department have been undertaken various activities for the regeneration and conservation of forest, which is critical for maintaining ecological balance and for ensuring better environment. It would be in the interest of the department that works like petitioner who are committed to discharge their duties to be encouraged and benefit under 2012 Act be extended to such petitions if they are found to be eligible. This court hopes that the exercise would be completed within a period of 6 months from the date. Lordship, in Annexure R1 is the endorsement. After considering the order, this one report, a detailed endorsement is issued.
Yes, petitioner.
My lord, my learned friend referred to the last para 5 only. Para 5 only. Para 5 was regarding the benefit available to the petitioner under the Welfare Act of 2012, my lord. But your lordship may kindly the first sentence of para 5, respondent number 2 shall also consider. That means this direction to comply with 2012 Act is a second direction issued in addition to the first direction at para 4. Direction at para 4, which I read out earlier and I repeat now, in the light of the above factual matters, the court is the considered opinion that the instant position can be disposed of directing the inquiry by second respondent with regard to the allegation of non-compliance of the provisions of the Labour Act and payment of provident fund and gratuity by the labour contractors. If the same is found to be correct, the respondent shall initiate. Therefore, this is the first direction to find out whether the so-and-so labour contractors have conducted, given the provident fund and other things. That they have not done. What my learned friend read out is only regarding para 5. They say under the labour, that is Karnataka Social Daily Wage Welfare Act.
Problem when you people appear online.
My lord, I'm sorry.
You don't encourage appearing online. That is the difficulty because you don't understand the query. Now you see paragraph 3 of the compliance affidavit. After inquiry, they have said that this case does not fall under the purview of Karnataka Daily Wage Employee Welfare Act.
My lord, that is
payment of provident fund and all.
My lord, the inquiry for the purpose of eligibility under the 2012.
File any reply to his affidavit?
Yes, I want to, my lord. I want.
File it for that, we will decide.
Yes, ma'am.
The counsel for the petitioner press for is allowed 2 weeks time.
2 weeks, ma'am. I am out of station, sorry, ma'am.
Filed by the respondent accused. This thereafter.
Yes, ma'am.
Been complied with, my lord.
So I filed a compliance affidavit relating to my lord's arrears of pension, freedom fighter pension, my lords. We have paid that. Some delay, my lords.
Contempt petition arises out of order dated such and such. Passed in the petition 7498/21, whereby direction was issued to accused to sanction freedom fighter pension with retrospective effect from 19/3/1998 and settle all the areas within a period of 6 weeks. You have filed affidavit?
Yes, miss, I filed it.
The affidavit of compliance has been filed by a respondent stating therein that the order passed by the writ court, counter affidavit,
yes,
has been fully complied. The counsel for the petitioner complainant agrees that the order of the writ court has been complied. In view of nothing survives to be decided is in contempt. The petition is dismissed, notice discharged.
11.
Page 18.
So we have complied the order. We got the copy.
No.
Sent through mail, I think. I complied the affidavit. The direction was to Miller's.
Direction was to pay salary from 2016.
Page 32, Miller single judge order. Page 32, relevant portion.
Where is your affidavit?
Yes, I filed on 15th June. I have.
It's
not there.
Single judge order plots we have assailed in the single judge direction we have assailed in the writ appeal. We have failed there. Now it is order has been complied.
Your Lordship may kindly take the para 5 of the. This is compliance.
This is the order.
What is the court order? First,
Your Lordship may kindly take page 18. Respondent number 4.
Page 18 of paper book.
It is Your Lordship.
It is Supreme Court order.
Supreme Court, Your Lordship, this is an SDA. 96 he was appointed. 90 they did not confirm his appointment. So he was before this honorable court in 2003. Succeeded in 2006.
This contempt petition arises out of which order?
The order of the division bench, Your Lordship, at page 20. This is against the Supreme Court order at page 18, which affirmed the division bench order at page 20, which
We are asking this contempt
Yes.
petition arises out of which order?
Your Lordship may kindly say the Supreme Court has merely reaffirmed the order of the division bench. So when the matter, this query was supposed to be before the other bench,
Are you here for compliance of the Supreme Court order?
Supreme Court order, which is merely a reaffirmation of
That
the
is why
division
we are
bench.
asking you, this is third time.
Please, then it's a division
Where
bench
is the order of this court which has not been complied?
20, page 20, please, Your Lordship. Page 24, halfway through, Your Lordship, will kindly see. Then it's single judge's order, Your Lordship, is at page 32. Relevant portion, Your Lordship, is at page 32.
Now, what has not been done?
Salary has not been paid since 96.
Yes, what is your stand?
Thus, that arrears of salary, Supreme Court has modified. I request my lords to kindly take page 18 of the paper book, my lords. The order of the Honorable Supreme Court, last para. The Honorable Supreme Court, my lords, second para says that they declined to interfere with the appeal filed by the state. Last para, respond number 4. Prakash Vidyalaya Education Society is direct to pay arrears of salary with a simple interest at the rate of so and so to the petitioner. First portion of the order of the single judge for regularization, we have complied with after the dismissal of the by the SLP by of the state. Arrears, now private education institution has to pay. Our order, we have complied with the order. But payment of arrears is concerned education institution, which Supreme Court has modified. That I have stated in my compliance affidavit.
You appear for the institution?
Institution,
Yes.
Lord's review petition is filed seeking clarification of the order of the Supreme Court. For the reason, my lord, this is an institution which is admitted in 1908. Unless the state releases a fund, I can't disburse the payment, my lord. Therefore, we filed a review petition. Subsequently, they issued us a notice for cancelling the recognition and also for withholding the grant in aid. That was also challenged subsequently in another petition. The fact remains not there. We were given representation to the state to release the funds so as to comply with this order. But the same view was not we expressed before the another time. Because it's a grant in aid.
What review has been admitted? You have filed the review before the Supreme Court?
Yes, my lord.
Supreme Court?
Yes, my lord.
Now, whether that has been admitted?
No, my lord. No, I am instructed now because there is some vacation notes. It will be moved very shortly. The matter will be moved before the Supreme Court.
Then merely by filing review, you cannot defer the compliance.
Not in that event, Lordship may grant another 2 weeks time. Not in that we will again request the Supreme Court not to modify this order.
We are not concerned with your review. We are concerned with the compliance. We are concerned with
Now,
the compliance.
now we have given representation.
Now, in view of the Supreme Court order, you are required to pay the arrears with 6% interest. Now show the compliance.
But complaints, as of now, as I submitted, we have given representation to the state to release the fund because it's a granting.
We are not concerned.
What's a grant?
We are not concerned whether you have to get the grant or you have to do anything else to arrange the money. We are not concerned.
Education is a granting agent. They should release the fund.
We are not concerned.
Lordship, in that event, may I request Lordship to grant me 2 weeks time. I shall make my endeavor as a last chance.
We can grant, if you say you will comply, then we can grant you time, otherwise not.
2 weeks, just Lordship may extend it at my request. I will make my endeavor before the Honorable Apex Court to get it order modified.
In June.
But the coordinate bench was also the view because this is granting it, first state should answer it, then the court reserves that after if they don't comply, then they will.
State has already in government order of regularization, we have put conditions specifically saying that.
Learned AGA appearing for
1 to 4.
Respondent number 1 to 4 informs that counter affidavit has been filed in the registry yesterday. However, same is not on record. The office shall trace the same and place it on record. It is submitted by the AGA that the state government has complied the order as the service of petitioner has been regularized. So far as full stop, so far as the payment of arrears of salary is concerned, it is submitted that in view of the Supreme Court order dated
5th October 2021.
5th of October 2021, passed in civil appeal number 1965/21, the respondent number 5, Prakash Vidyalaya Education Society, is required to pay the arrears of salary with simple interest 6% per annum to the petitioner. Learned counsel for the respondent number 5 wants time to file the compliance on his request. The matter is adjourned for 2 weeks to enable the counsel for respondent number 5 to file the compliance affidavit.
Civil appeal number 2011.
21 लिखा है इसमें तो. That is the civil appeal number 1965/2011. Just give back. Just after 2 weeks.
I appear for the complainant, my lord. This is a matter where the complainant, who is a Group D employee appointed in the respondent institution, my lord, had approached this honorable court for approval of his appointment. From the date other persons appointed along with him were approved. He was appointed initially on 13th February 1992, and his appointment was approved without aid.
This will be heard finally.
Yes, finally, my lord.
What I said that submit the matter requires hearing.
Yes, my lord. First, my lord, it may be posted in first week of August because I am out of country, my lord. Sorry, my lord. It may be listed any date in the first week of August. Ma'am.
If you want to file reply, rejoinder.
I have filed rejoinder. I have filed rejoinder, but I have to argue if your lordship, because I am appearing through the video conferencing, my lord, it will be
List the matter for final hearing.
first week of August.
The first week of August.
Much.
Number 13.
The service is awaited to the my lords has granted interim order and issued notice. Service is awaited, my lords. I'll unserved respond. I'll take fresh steps. My lords may grant 2 weeks time. State appeal.
What is the service report?
Notice has been issued on 19th.
The service on respondent. Whom? 4 to?
All 10, 13, 14, and 21.
Some of the respondent is awaited.
Respondents are deceased. Deceased. Some of the respondents are
Some of the respondents have been reported to be deceased. The appellant will take appropriate steps.
Please.
In this regard, office shall file fresh service report list after 3 weeks.
Right.
Number 14. Balakrishna Shastri, appear for the complainant, my lords. In this case. While the compliance affidavit, my lords, the orders of the honorable court have been complied with. The complainant and his family members have been allotted alternate sites, my lords, and to that extent, the sale is also been extended. My lords, the alternative sites have been granted to the complainant.
Nothing survives. This contempt petition arises out of order dated such and such, passed in petition such and such. The counsel for respondent informs that in compliance of Writ court order, the petitioner has been allotted alternative site.
The complaint has been allotted, my lords, 23,658 square feet of developed land.
The compliance affidavit has been filed.
Yes.
The counsel for the petitioner agrees that he has been given the alternative site in view of above. This contempt petition, nothing survives in this contempt petition. Dismissed, notice discharged.
Great. Number 15.
I appear for the appellant. Oh, I have filed this application for vacating the stay.
You filed the
Application for vacating the stay, my lord.
What is the stay?
My lord, it is public procurement and the successful bidder. Being aggrieved by that order, my lord, my learned defense client has filed an appeal before the appellate authority. The appeal is pending. Appeal is pending before the authority. And parallelly, my lord, writ petition has been filed. Having submitted, my lord, itself to the jurisdiction of the appellate authority, it is not open for the appellant to come and file a writ petition. The writ petition itself is not maintainable.
Matter is pending before the
Appellate authority, my lord. Pending, appeal is pending.
No.
Yeah, writ petition is pending before the 11th single judge. There, my lord, we have taken a contention that writ petition is not maintainable.
That ground was considered by the learned single judge. The appellate authority is the very person, my lord, who was obligated by virtue of a court order to procure these commodities. And therefore, we filed writ petition saying this appeal effectively is infructuous and it is not an effective remedy. The writ court, my lord, did not dismiss the writ petition.
Just we like one clarification, since both the sides are represented by senior advocate. What has been decided by single judge against which you have filed the writ appeal?
I, my lord, sought an interim order before the learned single judge, saying that this tender procurement being in violation of the central government regulations and state regulations, other procurement should not be undertaken. The learned single judge, my lord, deferred the matter for consideration without granting an interim order on a statement made by the learned additional and state council saying procurements are already complete. So we filed an appeal, writ appeal indicating that the procurements are not complete. A letter of award is issued. Prima facie, the letter of award is contrary to the central government regulation. Therefore, further procurement should be stopped. The writ appellate court.
What we understand is, subject to you people enlighten us, that unless a list is decided by the writ court, the writ appeal would not lie.
But kindly see the impugned order, my lord.
Just a minute, let him address first. What has been decided here in this order which is under challenge in the writ appeal?
The refusal of the anti-term order that we had sought, my lord.
There is no refusal. There is no refusal.
There is no grant. I understand what was from the notice. But I wanted an anti-term order saying that the procurements are complete.
If your IA for interim relief was rejected, then definitely you could have come before the writ appeal.
I understand the laws and IA being considered and my laws dismissed by virtue of a considered order, I could file a writ appeal. Because when I seek my laws and interlocutory protection pending consideration of the writ petition, and that comes up and no relief is granted, because I am entitled to approach the inter-court appeal in terms of indicating that I must be protected pending consideration of the writ petition or even the IA. Therefore, my lord, I am not shying away from the fact that I am willing to argue that interlocutory application even today. The appeal that the vacating that is filed there is my lord, the interim protection should be vacated. Lots of direct towards the learning single judge, of course, subject to my lord's consideration. The matter to be heard, because we are ready to for the matter to be heard, even if it is tomorrow.
That this order
Including the
does not even indicate that the interim order was passed. The only notice has been directed.
The issue relating to maintainability and Miller's availing appeal under section
Everything
60,
would be decided
that,
by the
yes,
learned
yes,
single judge.
that may be kept open. Yes.
That would be decided.
Yes.
We will request the
Yes.
learned single judge to
Very well.
decide the writ petition,
Very well.
hearing both the parties. Sir,
My lord, we have partly implemented, my lord, installed the machinery, my lord, medical equipment, we have already installed. And the direction from the sample court for speedy installation of these medical equipment. In the
since
Harvard.
the interim order is operating, we may say that you may not finalize.
Finalized, nothing is left out.
There was an order from my lords in a PIL for one equipment to be installed. We did not oppose it, that equipment is installed. There are about 6 other equipment which have to come in for installation. None of them are installed and we are sent for an affidavit. It is not the state says that all of them are installed. It is the private party says who says it is installed.
No, I am not saying everything is installed. There is one direction from the sample court which has been
That
implemented.
is fine, because we are not even opposing it.
And then in a part, how can you oppose and a part you cannot
Of course
oppose?
I can. The tender is bad.
whatever it is.
The question is, my lord, having invoked the appellate jurisdiction of the appellate authority, whether a writ petition can be maintained parallelly in abuse of the process of the court.
So on 30th of this month, appeal date is fixed, my lords, for the consideration of
June is coming up.
interlocutory application also, my lords, before the appellate authority. 2 appeals have been filed by the appellants hearing. That is, my lords, they are pressing there. That application is also coming, my lords, he is considering on 30th of this month. Appeal, 30th of this month. Date is fixed for hearing.
The state may not want to make that factually incorrect statement.
Notice
I have
is
on, 1 minute, sir. I have on affidavit, my lord, mentioned before the court that the appeal that I filed is completely infructuous.
Why it was filed
The
then?
person who is going to consider the appeal of judgment for Mr. Naveen Raj Singh, the principal secretary, is under a mandate in another PIL for implementing this very one instrument, that is one. Therefore, going back, this is another appeal from Caesar to Caesar's wife.
We are not concerned. We
No,
are
my
not.
lords may consider that, my lords, any other secretary can consider it. It's not that, my lords, that should not be a ground, my lords, to invoke under 226, my lords. There are other secretaries are there in the government, they can consider.
Authority was found to be
Merely because he has filed
there
affidavit.
is not even a whisper about bias against that authority in this petition.
No, he has filed affidavit
In
because my
another
lords
case-
has directed in that PIL.
We are not on that
Yes.
disposal of appeal.
Yes.
We will dispose of this intra-court appeal, requesting the learned single judge
Very
to decide the writ petition itself,
On
Maintainability.
including
including the maintainability
Yes.
of it,
Very well.
after hearing both the parties
Yes.
Please.
expeditiously
Very well.
as early as possible. And till the disposal of appeal, the writ petition, don't finalize the tender.
No, my lords, whatever the interim order is there, my lords, it has to continue. Same has to be continued. Because already work already is issued.
When a tender is finalized already.
Not the same interim protection that your articles have granted to continue. I am ready to argue the matter before the learned single judge. And my lord, the learned single judge is only listening.
We will fix the matter on Monday.
Please, I'm very ready.
Before the learned single judge. But this intra-court appeal arises out of order dated such and such, passed in writ petition such and such, whereby the learned single judge has granted time, 4 weeks time, to respondent to file a statement of objections. After recording the statement given by the Additional Advocate General, the court while entertaining this intra-court appeal has granted an interim order dated 5/5/2022, whereby it is provided that the further proceedings pursuant to impugned award of tender shall remain stayed till next date of hearing. Learned senior advocate appearing for the appellant submits that the learned single judge had failed to appreciate that installation of only one machine was done pursuant to award of tender to respondent number 4. The other machines were not installed. Full stop. The counsel for the respondent number 4, on the other hand, submits that the writ petition preferred by the appellant itself was not maintainable. The work was awarded to fourth respondent and it was under execution. Full stop. London AGA, next paragraph. London AGA appearing for respondent number 1 to 3. You appear for 1 and 2. Submits that statement of objections has been filed.
Yes, we are not yet filed.
No, we have filed.
We
That's
have
what number
filed.
4 has filed.
We'll file. Meantime, Millers will.
Submits that they will file the statement of objection within what time?
Before the next date, Millers, either in Monday or Tuesday. Before that, we'll file. Within 1 week.
We can, respondent number 1 and 2 can file the statement of objection in the shortest possible time within 3 days. And the writ court may hear the writ petition itself finally,
Including maintainability.
including the question of maintainability. First of, we have considered the submissions made by learned counsel for the appellant as well as counsel for respondent number 4 and learned AG appearing for respondent number 1 and 2. We are of the conceded view that in the interest of justice, it would be appropriate that the writ court decides the writ petition itself after hearing parties' counsel. We therefore dispose of this writ appeal with a request to learned single judge to decide the writ petition after hearing parties' counsel, including the question of maintainability of the writ petition in accordance with law expeditiously as early as possible. For convenience of parties, list the matter before the writ court on
21st, my lord.
You have to file the statement of
Yes,
objection.
21st, 22nd, any.
20.
Yes. 22nd, 24th.
Huh?
Then 24th, let him also file, rejoin if wanted to file.
24th.
Yes.
The interim order granted in the writ petition, in the writ appeal, dated 5/5/2022, shall remain operative till the disposal of the interim relief application by the writ court or
The writ petition.
disposal of the writ petition itself. Yes, I see that. Yes.
Number 16. Shakari.
Now, the encroachment has been removed.
No hearing now, afterwards. List for hearing again after 2 weeks. After 2 weeks.
It's appear for the petitioner, my lord, in seal number 17. This matter, my lords, pertains to the challenge of levy of service tax and royalty, my lords. The very same question is pending before the Honorable Supreme Court, my lords. And the tentative date, my lords, what is shown is 1st of August 2022.
Counsel for petitioner informs that the controversy involved in the writ petition is drawing attention of Apex Court, where the matter is fixed on 1st of August 2022. List in the 3rd week of August.
Grateful.
This case in the 3rd week of August.
Number 18.
Lord, I had sought for some time to file an amendment application. I have not been able to get a copy of that order. It's an order passed by the state. It's an order not being relied upon by respondent number 41. If they can be not directed to produce a copy of the order, because the state has subsequently, that is, subsequent to the date on which I prayed for amendment, the state has filed an additional statement fully supporting my petition. But the short point is about 8 required considerations. Hearing is required. You have filed objections, additional objections.
You
required.
Who is respondent 41?
I appear for this respondent number 41, my lord.
Have you annexed the copy of that order? No. Copy of order which he wants to challenge by way of amendment.
Kindly
He
grant me,
doesn't have it.
kindly
You have
grant,
brought it. To the
kindly
notice.
grant me a 2 weeks time, my lord. I will furnish the copy of the order. Please.
You give it a copy to him, then we'll only postpone the
Doctor,
matter.
I would like to
Postpone
file
the
my-
matter. It is between you and him. You take copy from him. He will give it to you, and then you make good the office objection.
Please.
We'll postpone the matter.
Kindly grant me 2 weeks
Request of
time
parties
to file my
council.
objection.
List after 4 weeks.
Great.
Number 19. Ravi Kumar NC.
Lord, appearing for respondent number 3, my lord, in this case. We are filing our report, my lord. As per
Have we given copy to other side?
fine.
First give copy and file it in the registry. Give copy to him also.
Please, ma'am.
Counsel for respondent number 3 informs that the report has been prepared. He will file the same in the registry after giving copy to the other side, to the petitioner. List after 2 weeks.
Please.
Number 20. Ramesh Naik. A party in person.
Petitioner has to comply with office objections and my lord, the amended copy of the petition was ordered to be filed, which is not done. Last some hearings he has not appeared also.
No, it's physically I have carried out the amendment and I also applied a copy.
What the Shara shows.
Non-filing of amended petition.
That's what it
To the court, I have not filed, my lord. I'll file it in a 1 or 2 days, my lord. Monday I'll file. But to the opposite side, I supplied a copy to them, my lords.
Lordships have to get the amended copy. Ours is we all right. I have not insisted.
Let him serve.
Amended, I carried out the amendment and supplied a copy, my lord. But amendment petition, I have not filed probably. I will file it in a 1 or 2 days, my lord. Monday.
In person undertakes to provide the amended copy of writ petitions within 1 week. Just
Grateful.
Dr. Bundy.
21. 18 AM.
But performer affidavit was supposed to have been filed, my lord. It has been filed. Already it has been complied by my lord, but there was a delay. Today morning it has been filed. Therefore, an objection has been raised on that.
But order dated 5/4/2022. Lordships have allowed the BBMP to put up construction without prejudice to the rights and contents of the parties and subject to the outcome of the writ petition, that we have commenced it. Paragraph 6.
Yes. You have completed the construction?
No, Malad, we will need about another 45 to 50 days to complete the construction, which we will do. This writ petition, Malad, could be disposed of.
Lord, with respect to the submissions that was made by the Learned Counsel, my lord, the submission that was made on the previous date, that 5%, up to 5% construction can be permitted, my lord. But according to the Act, my lord, it says there is subjected to as to what constructions can be permitted in the said 5%. Now, also, it also states that the constructions which has been, whatever constructions has been made, the said constructions as well, my lord, that with respect to the drains that is next to that, there is a particular standing as to what is the meter of distance that is supposed to be kept for. In that regard, I had filed an application requesting for the building plan, my lord. No matter how many times I filed the application before building plan, my lord, they do not provide me, and they're delaying the process of giving me the building plan so as to for me to file the necessary documents before this honorable court, my lord. Now, the submissions that was made stating that 5% of limit, 5% construction can be permitted in the land which is disputed, that is the park property, was the submission made by the Learned Counsel, based on which the order was modified. With respect to that, my lord, 14.12 of the revised master plan and zoning of land use and regulations clearly indicate that constructions as to a particular usage, my lord, in which this market building which they are constructing does not fall under it, my lord. Therefore, I will file the necessary documents which I have sought. I have been told that in the next 7 days, I will receive the documents by the assistant executive engineer.
This is going on from 4th of October 2021. Lordship may kindly see the order sheets. From 4th of October, it is going on. That he wants, my learned friend wants time to get some documents.
My lord, if the council, if government is willing to submit just the building plan, my lord, I am ready for arguments, my lord. Only the building plan is what I am seeking. If the building plan is provided by them, this can be disposed of, my lord. If the building plan is not provided, my lord, one of the reasons for that is the Act says that G+1 is only permitted, that is ground plus first floor. Prima facie, my lord, the building that is constructed is ground plus 3 floors. And it is constructed right above the drain. Now, in order to support my standing, my lord, with respect to the said allegation that I made of my submissions, my lord, I need the document. And I have been seeking for the document, and the government has been delaying. They say you go on an appeal. On my RTI applications, they say you go on an appeal. Now, if government does not provide me the documents, I am left helpless, my lord. And only document if they submit along with the survey report that they submitted, my lord, I am ready for the final argument, my lord. Only document I am seeking for is the building plan. If government is ready to file the building plan, my lord, that is the second respondent. My learned counsel is present there. I think it should be a piece of cake for him to provide the said documents. If he provides that, we can dispose the matter of, my lord.
Message is adjourned today, just after 3 weeks.
Right.
File the document, whatever you want.
Yes, my lord. Much lord.
Number 22.
This is the conversion of Grama Panchayat area into tranquil in violation of the section 3 of the Municipality Act. There are certain conditions imposed on section 3 regarding population and the industrial output and all. I have given all the documents stating that it is a very poor condition village. They are converting to tranquility area in violation of the section 3 of the. And there is a similar condition. There is a Supreme Court judgment recently, Rajasthan Court judgment. It says that all the conditions has to be complied with. Then only they can convert to tranquility.
Yes, what do you say? Statement of objection filed?
Yes, my lord, statement of objection is filed, my lords, and we had filed a memo with certain document, my lord. There was some office objection on that, my lords. A week's time, my lords, I will comply with.
Without affidavit, they file it, madam. That's why office
AGA
objection.
prays for is allowed a week's time to make good the office objections raised on the memo
Yes.
for filing of documents.
Yes. And let there be interim order of status quo, my lord, because they are going ahead with the
Sorry,
conversion.
there is no interim order. Just in the month of August.
1 week.
Number 23.
Next week date is it?
J. Mohan.
But, petitioners intending to set up a coffee curing works in the land of first petitioner. Here they have obtained an NOC from the necessary authorities, including combined consent of for discharge of effluent under Water and Air Prevention Act. That is at page number 41.
You've seen the order dated 14/9/2021. You've seen the order dated 14/9/2021. Before passing an order, whether opportunity was provided.
Yes, that's the only condition. I will be able to demonstrate it with the records itself that an opportunity has been granted. That's my turn to annexure key page 80. Even annexure J page 78 minutes for a moment.
You filed a statement of objection.
We haven't filed statement of objections.
You file it only then we will hear the matter.
That there is an urgency in this matter. Only opportunity has not been given to us.
That
For
they
passing.
say that opportunity has been given, they will
And they
demonstrate.
see that in the writ petition itself, paragraph number 7 minutes.
So let them file.
They say sufficient opportunity is not given minutes.
May
We are
submit,
not
Millard.
concerned.
Millard, may submit, Millard. If they have sent the notice through post on the dated, Shoka's notice dated 5th October 2020. That has been reached us on 7th October 2020. And the 9th they have passed the order without giving opportunity. That is the contention.
Let them file the statement of objection, we will hear them.
Last occasion also.
Mr. Mahesh Chaudhary, learned counsel, appearing for respondent number 4. Place for is allowed 2 weeks time to file the statement of objection. In case any rejoinder affidavit is required to be filed, the petitioner may file the same within next week thereafter. Rest after 4 weeks.
Date may kindly.
4 weeks, after 4 weeks.
Because last occasion also they have been directed to file objection. So far they have not.
All right, then you will file this statement of objection.
24.
Much okay.
AB.
The compliance affidavit.
Yes.
Just 2 days before they filed a compliance affidavit, it can be drawn.
It's complete. Body and Durasti work has been done.
This contempt petition arises out of order dated such and such pass the writ petition such and such. Then an AG appearing for respondent submits that compliance affidavit has been filed in the registry on
Lord's 15/6/2020.
15/6/2020.
Yesterday.
2022. Our same is not on record. Office shall trace the same and place it on record. It is submitted that order of the writ court has been fully complied. Para. Learned counsel for the petitioner complaint agrees that the order passed by the writ court has been complied. As such, nothing remains to be decided in this contempt petition. Contempt petition is dismissed. Court is discharged.
Number 25, Amy Charity.
For the appellant in this case.
Well, the second is one. I have tried my statement of objection.
My senior is unwell, my lord. Kindly have any other day. My
Yes.
senior is unwell, my lord. Kindly have any other day.
Again, on the request of counsel for the appellant, list after 3 weeks. Interim order, if any, shall continue till next date.
Number 25.
Be careful. Age. Sometimes I don't know. I was going to the judgment. My lords were pleased to wait today. I want you, my lords, to kindly have a look at para 5.8. In Caparo's case, Caparo's 5.8. Not there. I have made the compilation here. There's no
Same, right, same. So, the appeal is not met. Petition page 2006. And that can be full bench and judgment. The appeal is not met. It is silent reflect. And the petition will be under 47 under the restriction. 26.
Petition history.
and 227. 5.8, paragraph 5.8 of in Caparo's judgment. Now, so far as the submission before the appellant, there is admission before the single to the High Court, fact was under Article 226 of the Constitution of India, not under Article 227, and therefore appeal would not be maintainable. Is concerned, it is submitted. In fact, in the cause statement, the appellant has stated admission is under Article 227 of the Constitution of India. All throughout their expression was under Article 227. Mine is under 226. I never went near 227 in my expedition. Ask for a session. It is submitted, therefore, now thereafter is open to the appellant to contend. Petition under Article 226, and therefore it will be maintained. It is submitted. Therefore, both the signature of division bench have rightly held that the petitions were not in fact under Article 226, 227, and written were not maintained. Then, my lord, your lordship kind of quote 7.9, which my lord was pleased to point out.
Whether the writ petition is on record? Copy of writ petition? Copy of,
Ours, yes, yes, of course. The writ petition is the matter book. The master stationery.
Page 69. Page 69. Page 69.
Page number 69 of volume 1. Memorandum of Requisition under Article 226 of the Constitution of India. 227 was never invoked. And we have asked it to stationery.
you have challenged the award.
Award. And 7 judges of this court have held writ petition is made appeal maintainable.
Considering the full bench, the division bench has subsequently held that division bench of this court itself has subsequently held that writ appeal is not maintainable.
Sir, my submission, my lord, is
You kindly see the judgment, Justice Dattu.
Lord, I am citing 2009. I am citing the for subsequent judgment.
Whether you have prayed for certiorari or you have
Lord, Justice
said that it should be set aside is one and the same thing so far as the award is concerned.
1 second, Lord. Kindly see, Lord. The full bench of this court in para 4 of the judgment has after requests are filed before this court both under 226 which when such is the case, the court has to examine the allegations made in the petition and relief claims therein as to whether the petitioner wants the court to exercise power supervisory jurisdiction power under Article 226 or its original jurisdiction 226 Constitution. There can be cases of claim seeking to invoke the power of the
Read
court
para 7,
in
sir.
both articles.
Read para 7, sir.
In the instant case, it is not the case of that he questioned the award was the tribunal never court. In any one of the exceptions stated by the full bench of this court in Guru Shanti. Therefore, in open heart by single judge, that the Article 27 the appeal he said order before this court. My submission is 7 judges of this court have clearly held that upholding Patedar.
Correct. Patedar judgment has been relied in this division bench.
My submission is, your lordship had examined now kindly see the latest judgment of the Supreme Court, 3 judges of the Supreme Court.
Same problem is in jurisdiction 482. Now, what has happened? The same problem has arisen before us in the criminal jurisdiction where the petitions 482 read with writ petition is filed. Now, the Supreme Court has recently clarified this, that the writ appeal would not lie. It may be read as a writ appeal or a writ petition or under 482, but the writ appeal would not lie under the criminal jurisprudence. Now, because of this full bench judgment, the same thing, we are also considering that question in other matter. Same is position here. In all such matters which arises out of labor code, the writ appeal would not lie. And same is the position in all other high courts.
Your lordship will have to see whether what is invoked is 227 or 226. Kindly see the judgment of Supreme Court.
No difference so far as the award is under challenge. Whether it is under challenge under 226.
Capara is by 2 judges. This is Sham, this is Bhuvana. Here is another 3 judges. Now, Justice Ashok Bhushan, Justice Ramsey, Justice Hemant Gupta. They say it makes 226. This is April 2021, 3 judges. Paragraph 18, 1.8. Paragraph 18. A perusal of the procedure to section 9 of section 9 shows that it confers a power upon the call to examine the records relating to any dispute, question, or other matter, which has been written by the tribunal for the purpose of satisfying itself as to correctness, legality, or propriety of such determination. In fact, the statutory portion is acceptance of the principle that jurisdiction of the High Court under Article 226 or 227 Constitution of India cannot be curtailed in terms of Chandra Kumar. Next, as a three-judge bench of judgment report in the Adesham and the tribunal, the observation by the judgment Surya Devi Rai cannot be good law. In Surya was settled in order of civil court to be challenged in the petition 226, and the distinction between Article 220 suits 7 of the Constitution of India stood almost obliterated. So they say it doesn't make much difference. Once blood, all these years, the petitions have been entertained and determinants have been entertained following the 7 judges' judgment, where their lordships can have a look at it. The judgment, compilation number 5, Tamanna case. At paragraph, my lord, their lordships consider the effect of various judgments, and at page 17, paragraph 3.13.2.
Nomenclature of the proceedings as petition under Article 226 or petition under 227 is wholly inconsequential and immaterial. The judgment which we have passed on, it itself says so.
Then, my lord, conclusion in Fatedar, that is Tamanna's case, 7 judges, at page number 35. Holland reporter, your lordship gives a conclusion. That an intra-court appeal is not maintainable under Section 4 of the Karnataka Constitution, order for a single judge to make anything against the order made instead of the issue passed by a court subordinate to the High Court.
That might be committed by the subordinate to the present petition, though filing.
But may I read paragraph 3.13.2 in Tamanna's case, 7 judges judgment. The full bench consisting of 5 judges, after referring to Umaji's case, 1986 Supreme Court, drew a distinction between the power under Article 226 and 226 of the Constitution of India, and held that while proceeding under 226 are in the excess of original jurisdiction of the court, the proceedings under Article 226 of the Constitution are in excess of supervisory power, since Section 4 of the Karnataka High Court Act, when read in the context of original supervisory jurisdiction, intra-court appeals provide only against the order of a single judge passed in excess of original jurisdiction under Article 226 of the Constitution of India, but not against the order passed in excess of supervisory jurisdiction under Article 226 of the Constitution of India. Before proceeding further, it is apt to refer to ratio laid down by the Apex Court in 86 of the Court in 22. A proceeding under Article 20 is the original proceeding, and which concerns civil rights, it is the original civil proceeding. Consequently, where a petition filed under 226 the Constitution is according to the rules of the particular High Court, heard by a single judge, an intra-court appeal will lie from the judgment of such right or appeal provided with the character of the High Court, where such redress patent or a statute. A proceeding under 227 is not a kindly see the questions of and reference made. Their lordships clearly say a 226 petition, a writ appeal will lie. Kindly see, my lord. Paragraph page 19 of the, this is 80, para 18, 3.4.
227 we do not like.
3.13.4. Section 4 of the Karnataka High Court Act, an appeal has been provided an order related single only when it is possible in excess of the original jurisdiction, which is held under 226 of the Constitution of India. That the power under 227 of the Constitution being supervisory, no intra-court appeal is maintainable against the order because the right of appeal under 4 of the Karnataka would be a statutory right. The same can be exercised as provided under the same statute, but not otherwise. Rules 3 and 4 of the Writ Petition do not provide for an appeal against the order of a single judge passed in the exercise of supervisory jurisdiction. And then 3.14.1, the maintainability of an appeal under Section 4 of the High Court of Act against the order of a single judge passed in excess of foreign to the Constitution again came up for considering Vishnu Ganapati Naik and case ITC and for a short Vishnu Naik case, wherein the workman agreed by an award of the industrial tribunal. Then, my lord, they go to show at page number 19. If the challenge is limited only to the correctness or otherwise of the award, then the petition obviously invoking the powers of the court under 427 of the Constitution, because the case has not been initiated for the first time in this court. If in addition to the correctness of the award, the petition were to challenge the virus of any provisions of the Industrial Disputes Act or any other provision or the very jurisdiction of the Labour Court to pass an award, on the ground it suffered from the error of law apparent on the face of the record, he is invoking the High Court under Article 226 as well, and such cases issue will be deemed to be have been entered in excess of original jurisdiction 226 of the Constitution, and came to the conclusion no appeal would be liable against the award passed by the excess also. So after considering all these judgments, the High Court held, the full bench, the full court held that it is 226 petition appeal is maintainable. In Capera, what happened, the judgment allotted by Justice Shaw, what has happened is that they did not even invoke 226. That's why they said, if you can't ask High Court to convert it to 227 to 226 or something like that, you did not even ask for a certiorari. Therefore, even then, we are examining it. That's a different matter. Under 142, they were lordships of 141. They can examine anything they want.
Dissenting view. Gopal Gowda. You know, this is last this paragraph for you. While differing with the
Therefore, their lordships say like this, Lord. That is, Lord, the first is compilation. Compilation number 1. Petitions are very often filed both under Article 226 and 226 of the Constitution. When in such case, this is the case, the court will have to examine, having regard to the nature of allegations, the petitioner wants the High Court exercise supervisory jurisdiction under 226 or 227 or its original jurisdiction 226. There can be cases where a claim is made seeking to involve power of the High Court under both articles. For instance, the award of the Labour Court is sought to be challenged by a petition for 226 and 227, the Constitution. If the challenge is limited only to correctness of the award, the petition is obviously invoking the power of this court under 227 because the cause has been initiated for the first time in this court. It has arisen before the Labour Court who has given a decision from the award, the correctness of which is challenged. If in addition to correctness of the award, the petitioner is challenged the violation of the provisions of the Interest Goods Act or any other provisions very limited jurisdiction of the Labour Court to pass an award on the ground it suffered from error of law apparent on the face of the record, he is invoking the powers of the High Court under 226 and if such issues are decided by any single judge, decision will be deemed to have been rendered in exercise of its original jurisdiction under Article 226. This aspect has also been examined by the lordships in Umaji's case. However, the case before is not a case of that type because the learned counsel appearing with the verifiability considered that by he is invoking the judicial report under 227. That is entirely different. I have challenged the correctness of the award, showing apparent errors of the law, not following the constitutional judgment of the Supreme Court in 2 decisions. And according to 7 judges as well as 5 judges, my appeal is maintainable before your lordships. And in fact, the very same view as expressed by Justice Hemant Gupta, he is expressed by his lordship Justice Prasad in 2009 in the second compilation. Their lordship referred to Surya Devi Rai in para 12 of the judgment. That is the compilation number 2. From the aforesaid enunciation of law is quite vivid and luminescent that the pleadings in the expression nature of the order passed by a single judge, character and contour of the order, directions issued, nomenclature given, the judicial perspective of the constitutional context are to be perceived. It cannot be said that the hyper-technical manner that an order passed in a writ petition, if there is to assail the order, everything is so inferior tribunal or subordinate has to be treated all the time for all purpose to be under 226 Constitution of India. Phraseology used in excess of original jurisdiction under Article 226 Constitution and section cannot be given a restricted or a constricted meaning.
Let us understand which petition is filed under 227 in such matters.
Yes. This is under 226. Error apparent on the face of record. I am questioning because Christian Medical College case, the Supreme Court said an award passed by the tribunal is amenable to be reviewed by the High Court under 226. When a petition is filed under 226, under Section 4 of the Karnataka High Court, I am entitled to file appeal. If it is under 227, then the problem would arise in the subordinate.
Now, in which case it will be under 227 and in which case it will be under 226?
Yes, Lord. That has been decided by your lordship by seeing the petition itself. Whether what power I am invoking, what is the relief I am seeking. That's what this is precise.
In both the petitions, it will be the challenge to award. The award is challenged.
Yes.
Mere changing of nomenclature.
Subsequent to the
it will not change the effect. This is what Supreme Court has said in this judgment which you have cited, Hemant Gupta. This is what has been
that is there.
That has to be treated under 227.
doesn't make much difference because that was the case under 83. of
Therefore, the
Act.
petitioner style as one under 226 would not bar the High Court to exercise jurisdiction the Act under 227 of the Constitution.
Yes.
The jurisdiction of the High Court to examine the correctness, legality and propriety of determination of any dispute by tribunal is reserved with the High Court. The nomenclature of the proceedings as a petition under 226 or a petition under 227 is wholly inconsequential and immaterial.
Correct.
So it doesn't make a difference whether you name it under 226 or 227. It has to be treated under 227 only.
Power to entertain like if it is under 226.
No,
Not otherwise.
Subsequently, the Supreme Court has clarified it. Now,
That case, Caparo's case.
Same legal issue was raised before Andhra Pradesh High Court. The division bench has held the same thing. Just
relying upon Radhesham judgment.
And in fact, that judgment says a petition will not, cannot be, High Court cannot examine the even question of law. I'm sorry to say. My lords know it. Therefore,
observation 223 में कहा है. It has to be treated under 226.
they specifically say so. The last paragraph.
Petition to file
It has to be treated under 227.
Para 27, therefore, appeal is not maintained.
Same is the position here. Whether the merely changing the nomenclature will not change the nature of the case. The position is that in view of the Supreme Court judgment, all such matters where the writ petition has been filed arising out of the order passed by the Labour Court, then it has to be treated under 227 only. This is what is being said.
With great respect, Lord, I think that may not be a correct view. I bow to your Lordship's views, but I cannot but submit that matter requires
We are not
consideration by
saying
Lordship.
ourselves. This is what Supreme Court has said.
Supreme Court kindly see, my Lord, 5.8, the Lordship says, you are not even invoked 226. That's what they say. You can't ask the High Court to say, construe it at 226.
In that particular case, they have tried to draw a distinction that he had not even filed the petition under 226. It doesn't mean that it has to be treated under 226.
Correct. Therefore,
before the Supreme Court, in that matter, the petition itself was filed under 227. And they have said that it is not even filed under 226.
But in Tamanna's case, 7 judges and Fatedar's case, their lordships make a difference about the supervisory jurisdiction of the High Court under 227 and 226, the original jurisdiction. It is not just an award being questioned, habeas corpus, mandamus, so many things are under 226.
Please try to understand the concept. Concept of drawing the distinction between 226 and 227 is that under 227 it is supervisory jurisdiction of
Can we exercise suo moto, but not 226?
226 is
So their lordship says so. I am not saying this. Their lordships, the 7 judges, they say you can exercise the power suo moto also under 227.
Yes, under 226. 227, because the labor courts are itself
they have been held to be not courts, civil courts. They have been held to be not civil courts.
Labor courts are also the judicial authority. Therefore, under the supervisory jurisdiction 227, the writ petition is filed.
Your lordships have not exercised supervisory jurisdiction over labor courts under 227 at all. Even though Justice Ramaji tried to include that in one of the judgments, his lordship was taking that view.
The concept
that they must be brought under 227.
Even the concept of writ appeal is to provide a forum of appeal in the High Court itself against an order passed by learned single judge, where he has passed the order on the original jurisdiction under 226.
But if lordships are of the view that no appeal lays against the order of a single judge, even under 226 an award passed by tribunal,
No, against an order passed by learned single judge in exercise of power under 226, the writ appeal would lie.
While I respectfully...
But this order cannot be treated to be under Article 226.
Suppose, my lord, I am able to point out the honorable single judge has committed a grievous error of not following two constitutional judgments, quite contrary to law. Even then, your lordship will say, no, we won't interfere. Will your lordship have no power at all? Two constitutional judgments should be ignored. On the same point, Supreme Court says so. That is ignored by the court. Single judge judgment of the High Court ignored by the single judge. Even then, my lordship will say, no, sorry, you are 227.
Take all these plea you can take before the apex court. You are not remediless.
That, my lord, initially the petition was drafted only to file in the Supreme Court, having regard to Jaipur Zilla. But I decided, why not take a chance? Because when you, lordships, when you go there, you say, why have not exhausted your right of appeal? Go and we give you go and appeal. Then what will happen? I had to come back to your lordships again. Therefore, I have to file an appeal. I will take a chance. If your lordships are not convinced that Patedar and Tamanna's case are not applicable, I cannot say anything more than that. Because according to me, the honorable single judge had committed a very serious error.
Or I will pass the order.
I am obliged to lordships.
Order reserved.
Lordship, please.
But 27, J. D.
This case, the subject matter of the case is in context to the temple. That is petition number 1 temple, Sri Chaudeshwari Devi temple. The same temple is in Kolar district, Kolar Thanda. The temple has been in existence since decades. During the year 1946, there will be an application which will be made by one by name K.S. Subba here, seeking for grant of 2 acres of land out of the scheduled property. The entire extent of scheduled property is 3 acres and 11 guttas, which has been meant for temple and for the temple devotees, right from the centuries. Thereupon, the said grant will be allowed by the revenue commissioner, then revenue commissioner. And out of the villagers' protest, the said grant will be again subsequently cancelled
on 19/2/1946. Then again, Mr. K.S. Subbayar will go for an appeal before His Highness Maharaja of Mysore. Then His Highness Maharaja of Mysore will hear both the parties.
This is PIL.
PLS, yes, yes.
You are challenging the order
Land
of
Tribunal
the,
order which has been passed on 25/3/1985.
So, who are you?
I am for the petitioners.
No, you are for the petitioner, but who are the petitioners?
Petitioners are the villagers who are neighboring villages in Kola district from E-Com.
How in a PIL can you challenge this order?
Here the subject matter is the earlier order which has been passed by His Highness Maharaja of Mysore. It is only for the government purpose. It is only for the temple. I'm just giving the backdrop of the case. If you can permit me, I'll just give the backdrop of the case. The government order.
If you are agreed by this order, then it cannot be PIL.
Here again, there was a writ petition which was filed, and the writ petition was withdrawn.
In the PIL public interest litigation, can you challenge the order passed by the respondent number 1, Land Tribunal? Now, what has been done by the Land Tribunal? It has decided some rights of the parties.
Land Tribunal. Actually, what the villagers had given as per the order dated 14/2/1947, the villagers shall maintain the temple. Your Lordship, kindly go through Annexure C, Your Lordship. Annexure C.
Lords, not able to go through the file, my lord, because there is totally mismatch, and the same thing have been repeated, my lord.
It is only the volume 2, 3, and 4 of the affidavits.
You forget about the contents.
Yes, my lord.
Come to the prayer.
1985 order, my lord.
We only see the prayer first.
Yes, my lord. Annexure E is under challenge, my lord. Annexure E.
What is that?
Annexure E is the order.
Page
second.
Page 1114.
Page
1114, there is some affidavit.
Volume 5. Annexure E. Before going to annexure, Your Lordship, there is annexure C. Annexure C.
Were you a party before the Land Tribunal?
We were not made as a party. The whole contention is Your Lordship. Here, annexure C is the government order, page number 250, Your Lordship.
How can you challenge this order, Mr.?
Lordship, because it doesn't come under Muzerai department. It doesn't come under Muzerai department. The temple doesn't come under Muzerai department. The Tahsildar had represented as a Muzerai officer, but the government order has been clearly passed in page number 250. Kindly see page number 250. My humble request. Page number 250. 250. Page number 250. Type portion is.
Order of the tribunal. Then you can at the most file a writ petition before learned single judge. Not in the PIL.
We have already filed it. I'll give you the background of the case. WP 36417 of 2012. The villagers had filed a writ petition challenging the order of the Land Tribunal.
So why this PIL?
Now, there again, there was an observation which was made out by the single judge, stating that this is of public cause. If a PIL is been advised, you can file it accordingly. Writ petition was again withdrawn, Your Lordship. Writ petition was withdrawn. Then they again filed WP 4109 PIL. In that PIL, there is no speaking order, Your Lordship. That is the whole contention here. The whole purpose of coming before this honorable court is because the whole WP was dismissed. The WP was dismissed because the senior members, because the petitioner was not a senior member.
You go through the petition. If you understand, then please make us understand also.
Lords, kindly see the cause title. The petitioner, first petitioner is the temple. Again, in the order, the second mandamus is to restore the name of temple. And he is representing one person. How he
No,
is
he says that learned single judge has said that it is a public cause
Yes, Lord.
for PIL. That is why he has
Lordship,
filed it.
kindly see the writ petition is also annexed here. There also same thing they have done. All the petitions, I will go through it, Lord.
You please go through it and then
Yes, I will make it.
explain it to us.
Yes.
We will have it again on some other date. Let him go through the petition and
Much of
make his submissions.
because there is a local standing which is there before the Honorable Court. One is about the public cause and the bona fide petition. Because none of the villages they have vested interest towards the property. None of the villages.
That is, we are saying that you cannot challenge this order.
Here again the PL was again dismissed without any speaking order. Then thereupon we went to the civil court. We filed OS number 425 of 2015. That again was dismissed. Stating that it is a public cause. Agreed with the said order, we have come to this court. Announcement was sent to the village accounts that no grant should be entertained at any point of time in the year 1947. Subsequently, K.S. Subbaya's grant will be cancelled.
Already PL came to be dismissed. We had ordered it.
No, PL was dismissed with the conditions, with the observation stating that the villages were infants and villages were not grown up at that point of time. But the case here, is, I have only two conditions. The case here is,
on the ground of delay in latches, come to page number 1195, para number 3.
Para number 3.
3.
Those are 195. WP 4109 order. WP 4109 order is 1190, 1190, 1195.
Page number 1195, paragraph number 3.
Second.
Paragraph number 3.
Also believe that the repetition survey is not maintained. Delay latches not maintainable as the dietary in question was
Again, paragraph number 5.
Dietary representative.
Again, paragraph number 5. Again, paragraph number 5.
3.
Read para 3, sir.
According to them, only on the ground of delay and latches, the writ petition has to be dismissed. In addition to that, we are also of the view that the writ petition filed by the petitioners is not maintainable because the deity in question was represented before the tribunal by the Tahsildar, who is the Muzarai officer. The Muzarai officer is also incidentally the member secretary of the land tribunal. Therefore, the petitioners cannot contend that the temple was not represented by any of them. The whole contention here is the temple itself doesn't belong to Muzarai department. And the villages are the proper and necessary parties who should have been made.
This order. Have you challenged this order?
No, this order, after this order, because once it was dismissed, we again went to the civil court because both the repetitions were dismissed. Again, in the civil court, we had filed OS for declaration. In that declaration, they had filed an application under Order 7, Rule 11A and B. And the said application, because the matter was of public cause and it was agrarian in nature, it cannot be entertained. And even we have filed one RFA as well, because that is still for consideration. RFA 1217 of 2020. And here, in paragraph number 5 and 6, they have clearly accepted that the deity is in possession of the property, right from the age-old days. And government order has been passed, and the endorsement was sent to the accounts, then Revenue Commissioner, then Tahsildar, that no such grant should be entertained.
Lordship, kindly see Annexure L. Even in the suit where he sought declaration to represent himself as the representative temple, that suit itself is rejected, my lords. Article rule 11 application is
There is
allowed.
even one Lahore judgment which we have cited.
That
Lahore
is also
judgment.
not challenged.
That is about the community.
Which are available.
Because the Lahore judgment, that is again about the community ownership. Because there it was the council was pertaining to the burial ground. Public place. Here again it's a temple. There if any of the parties has been ousted, then it is attributable to any of the members of the said community. There is nothing limitation. There is no Article 113. The Limitation Act doesn't prevail. I shall convince this honorable court. Let it be taken up.
We are convinced that your petition is not maintainable.
It is there. If you can put across, let them put across the views. Give me one more opportunity. I can convince this honorable court. Because there is a public cause, there is a public grievance which has been made. Because we have sufficient cause and bona fide intention. None of the petitions having any vested interest. And grant was not supposed to be made. That was the observation made by government order. See, we are only relying upon the government order.
Why, how much money you have spent in preparing this matter, but it is totally misconceived.
Here, the government order, we are only relying upon the government order. Kindly, if you can look into Annexure C, because Annexure C, they have clearly mentioned, His Highness Maharaja of Mysore, that it should be meant only for the harmonious welfare of the village.
We'll give the reasons.
Let it be opportunity be given to file a writ petition. Will at least the opportunity be given to file a writ petition. We will challenge the land because there is a delay, there is a grievance. At least opportunity may be given.
We will only hold that PIL is not maintainable.
Okay, repetition, if you can give liberty for the petition, we file a
Let's
repetition.
withdraw this writ petition seeking a liberty to challenge the.
If you want, we can give you liberty.
For the first petition, we had withdrawn.
If you withdraw this, then we can grant you liberty to challenge the order passed by the land tribunal before the appropriate forum.
I will withdraw.
The public interest litigation has been filed seeking following relief. After arguing the matter at some length, Learned Counsel for the petitioner Vijay Raj D makes a statement at the bar that he does not want to press this writ petition. It may be dismissed and is not pressed. However, with liberty to challenge the order, impugned order passed by land tribunal before the appropriate forum. The writ petition is accordingly dismissed with aforesaid liberty.
If permissible under law may be added, because they have already done that. They have already done that one round of exercise of challenging that order also. Even in the writ, they have done this.
Before the appropriate forum, that was also in PIL.
No, even in the writ they have filed.
Single judge also.
Single judge, they have filed a writ petition, Lord, that they have withdrawn and they have
Now the second writ petition will not be maintainable. It will be before the appropriate forum. We have said appropriate forum. We are not said writ petition.
If permissible under law may be added to be unsafe.
Challenging the land tribunal order 25/3/19. Land tribunal. It has been marked as Annexure E. No, that was subsequently withdrawn, Your Lordship. The first writ petition was subsequently withdrawn. It was withdrawn.
OP file ki wo bhi dismiss ho all the contentions including maintainability pending.
It is to be noted that petitioner had earlier filed the writ petition, which was dismissed with liberty
First
to
petition
file,
was withdrawn.
liberty to file the public interest litigation. The public interest litigation filed thereafter was also dismissed.
Number 28. No, 14%.
It is infructuous minutes now. Infructuous prayers. Seeking for appointment of Honorable Lokai. Last date it has come. It's in the matter. Now read prayers have
Yes. This public interest litigation was filed seeking following relief. Learned AG appearing for the respondent informs that the post of Lok Ayukta has been filled and appointment has been made on the post of Lok Ayukta. In view of the writ petition has become infructuous, it is accordingly dismissed as infructuous.
Readings are completed.
So, you want this matter to be postponed? The request of counsel for petitioner lists the matter for final hearing in the month of August.
To file a report, my lord.
Yes. Fine. You go through it and then submit. Learned AG informs that compliance affidavit giving the status report has been filed. The learned counsel for petitioner may go through the same and make her submissions thereafter. Give it.
20th of July.
Public.